There are 600 federal district court judges and 179 circuit court of appeal judges. This is our army. These men and women will and must save our democracy. Your lawsuits are a call to action. It is a declaration to the courts that they have a power they were unaware of. They have the power to remove a president, a Supreme Court justice, congressman, and a senator. These judges need to wake up and realize the tremendous power they possess. The case against Trump is the classic open and shut case. The Colorado Supreme Court decision and the Jack Smith report are both admissible evidence under the rule that the court can take judicial notice. You need only ask the court to do so. You, your neighbors, and friends can testify to seeing the insurrection taking place on live television. You can testify to hearing Trump telling his mob to go to the Capitol and fight like hell. The court can also take judicial notice of Trump pardoning the insurrectionists. The 14th Amendment makes no allowance for a president's right to pardon. The purpose of the 14th Amendment is to purge delinquent government employees. As for a Supreme Court justice, read the New York Times article by Jody Cantor and Adam Liptak entitled How Roberts Shaped Trump's Supreme Court Winning Streak. After the appeals court ruled Trump is not above the law, Trump appealed to the Supreme Court. Roberts wrote a memo stating, I think it likely that we will view the separation of powers analysis differently from the appeals court. In other words, grant Trump greater protection from prosecution. He wrote this memo before hearing arguments. Both Kavanaugh and Gorsuch wrote responsive memos thanking Roberts for his, quote, remarkable work, unquote. If you name these justices as defendants, they will be required to testify under oath as to the actions they took to aid and comfort Trump. Their refusal to testify creates a legal presumption they did so to favor Trump, and though not necessary to your case, that they did so for an unethical purpose. You need to spell out their actions in your grievance, also known as a complaint. It is not difficult to name Congressman Jim Jordan as one who gave aid and comfort to Trump. Videos and written documents are abundant. But for each legislator you want to proceed against, you must spell out their conduct that constitutes giving aid or comfort to Trump. If this were any other case where a court was asked to remove the president of a large organization, the court would have no hesitation in doing so and appointing a conservator to act in his place during the pendency of the suit. You need to request a temporary restraining order and preliminary injunction. Request the appointment of a conservator due to the danger of irreparable damage that could be done to the country. You should spell out the damage Trump has done and what he is threatening to do. Suits in all 94 courthouses must be filed. These judges need to know you have their backs. Trump's army of lawyers has been depleted by his own unconstitutional actions against the DOJ. Remember, DOJ lawyers refused to move for the dismissal of charges against Mayor Adams, forcing Trump's top lawyer to do it himself. The remaining DOJ lawyers, still loyal to the Constitution, might not oppose your suit since they too have a duty to the Constitution. In your request for a preliminary injunction, you need to request that the authority of the suspect Supreme Court justices be suspended too. For those of you who are proceeding without a lawyer, you must be respectful but insistent. You must be capable and confident in parroting the information I have provided. In short, you argue to have Section 3 of the 14th Amendment enforced.